All right, 55th Fifth Course now in session. The Honorable Roy G. Meek presiding.
You may be seated. On the case, People versus John Elza Federley, counsel identify for the record, please.
Aaron Tomczyk appearing on behalf of Mr. Federley. He is currently incarcerated with the Michigan Department of Corrections, and it appears that there may have been a slight issue with the writ here today, Your Honor.
Is there other problems with the case?
Yes, Your Honor. I just discovered late last week that we don't have transcripts yet on this case for the prelim that was run. So I don't think that we can run the jury trial on August 17th. I think we need to adjourn that. I wouldn't mind making that a final pretrial. I think the other thing that we have to possibly that I have to look into, I guess, is whether or not MDOC is doing actual in-person writs for a trial. That may cause delays in this case.
Did either party request a transcript of the prelim?
It looks like, as I look further in our system, it looks like we did on July 21st. So, yeah, it was just recently. I'm not sure how we missed it unless it was during the time when we were switching from one case tracking system to another and.
I don't see a copy of it in our file.
Okay, I'll make sure that we follow up with that too.
So, about 60 days to get a transcript. You want the trial rescheduled for October or November?
Let's go with November.
I'm fine with November, Your Honor.
All right, we'll reschedule the trial for November. And you want to leave the 27th on for just as a, or the 17th on for a pretrial, or do you want to have a different date set?
Well, Your Honor, if we're not, as I said, we're not setting the trial till November. We could move that out closer to the trial date.
Well, if we can get it resolved, or is he insistent he's not going to enter a plea at all?
Have you had contact with him recently?
I have, Your Honor, and he has maintained his innocence throughout this.
All right. Why don't we set a status conference in September and a final pretrial in October, trial in November. We'll go from there, and if you get a copy of that demand, I'll make sure that it gets signed today. So we get the transcript order. Anything else?
No, Your Honor.
No, thank you, Your Honor. Judge, you said you were going to adjourn the pretrial, right?
Yes. Well, today's the pretrial, final pretrial, so we're gonna, put some stuff on the record. The trial date will be adjourned.
Okay, so we weren't going to make what I.
We're not coming back on the 17th of
Okay.
August. All right. We'll set a date for September, and then October, and then the trial date in November. Okay. And then, People versus Eric Karen, I don't expect that that's going since he pled in a couple of the cases and there's supposed to be a case dismissed.
No case dismissed. He's
but it's not dismissed yet. It's supposed to be. I thought there was a plea agreement or they plead in all 3 files.
Oh, well, there's gonna be a plea in the third one too.
Oh, okay.
We expect.
Yes. Okay, so it's still on for today.
Yeah, it should still be on for today.
All right, we're in recess.
All rise.
Can we get back to you as soon as we have Macaulay done?
All rise. 55th District Court now in session. The Honorable Roy G. Meek presiding.
You may be seated. On cases of People versus Robert Anthony McCauley, counsel identified for the record, please.
Good morning, Your Honor. Mark Bell on behalf of the people in 21-6589F. What's your?
May it please the court, Scott Moore for the defense.
You are Robert Anthony McCauley?
You need to unmute your microphone.
Yes, sir.
All right. And how are we proceeding this morning, Mr. Moore?
Your Honor, in 21-6589-FH, we are proceeding on the amended information that's been presented to counsel and discussed with the client, filed with the court with a reading of the amended information. We will be proceeding on count 1, the sole count of the information, as well as habitual offender second offense notice.
All right. How old are you, Mr. McCauley?
34.
You raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Being charged with jail, prisoner, possessing contraband, that's a felony that carries a maximum penalty of 5 years in prison and or $1,000 fine, plus you're being charged as a habitual offender second, which means the maximum penalty could be 7.5 years in prison. The minimum is discretionary court. There's one of 3 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you may make?
Yes, sir.
Answering to jail, prisoner possessing contraband, how do you plead?
Guilty.
Entering the habitual offender second offense notice, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be?
Yes.
Court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights: the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. You understand these rights?
Yes, I do.
You understand by pleading guilty, you give up each and every one of those rights.
Yes.
Mr. Webb, what is the plea agreement?
Your Honor, it's my understanding the defendant will plead guilty to count 1, jail as a prisoner, possessing contraband as a habitual second offender, dismiss the half third of the sentencing, and there's a sentence recommendation of 6 months in the Clark County Jail, which would run concurrent with any other felony.
Mr. Moore, is that your full understanding of the agreement?
It is, Your Honor.
What's happening with the other case, 21-6566? Is that included in this agreement?
That matter, I believe, was resolved by misdemeanor plea.
Oh, that's right. It was. Okay.
There was, or may continue to be, a probation violation not sure if we've dealt with that.
No, we haven't. Okay.
Since we have a representative from the department here today, perhaps we can take care of that as well.
I believe the judge did mention in that case that he was looking at 23 months in prison initially. I believe the department stance was to leave any sentence up to the court.
Trying to handle that case today, we probably need to get the file from the clerk's office.
Yes, Your Honor, I do know that my client wants to resolve these matters at the earliest opportunity.
All right. All right, we'll continue with the plea while the clerk said.
19-6076.
So that's your full and complete understanding of the plea agreement, right, Mr. Moore?
As regards 216589.
Yes. All right. Mr. McCauley, did you hear what was put on the record regarding this file as the plea agreement?
Yes, sir, I have.
Did you understand it?
Yes,
And are you in agreement with it?
I am.
Has anybody promised you anything beyond what was placed in the plea agreement to induce you to plead guilty?
No, they have not.
Has anybody threatened you or your family in order to induce you to plead guilty?
No,
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
no,
Is it your own personal choice to plead guilty?
yes,
And are you doing so freely and voluntarily?
yes,
Do you have any questions about what the court has told you?
no,
Have you understood everything that the court has told you?
yes,
In light of everything that the court has told you, do you still wish to plead guilty?
yes, sir.
Drawing your attention to on or about February 8th of 2021, were you in Hayes Township, Clare County, Michigan?
Yes,
And you were coming into the jail on that date? Is that correct?
Yeah. Sorry?
You were brought into the jail on that date?
No, I was here for a couple weeks by then.
All right. So and while you were in jail, did you come in the possession of some Suboxone?
Yes, sir, I did.
All right. Was that a controlled substance?
Yes,
And did you get permission from the jail to have that in your possession?
no, sir.
And is it true you were previously convicted of the offense of possession of a controlled substance on or about March 21st of 2016 in the 55th Circuit Court for Clare County, State of Michigan?
Yes,
Are you satisfied with the factual basis, Mr. Webb, or any
Yes, thank you.
questions? Satisfied with the factual basis, Mr. Moore?
Yes, Your Honor.
Has court complied with the court rules, Mr. Webb?
Yeah, Your Honor.
Has court complied with the court rules, Mr. Moore?
Yes, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate, has been freely, voluntarily, understandably, and knowingly made. Pleas are accepted and ordered entered upon the records of this court.
Your Honor, with regard to sentencing, I would ask the court to give some consideration to scheduling this for what had been reserved for the jury trial date of August 18th. PSI has already been prepared. We would have no objection to an update being prepared for this case. I do know that my client has some family matters that he wishes to attend to, and so the sooner you can get sentenced on his life, the better. Thank you.
Any objection to using August 18th for the sentencing date, Mr. McCauley's cases?
I have none.
All right, we'll set sentencing for August 18th at 9 a.m. Mr. Cordero, is that going to cause any problems for the department in getting an updated pre-sentence investigation report for these cases?
It may, Your Honor, because his last pre-sentence investigation was an update. So it'll have to be an entire new PSI.
All right. So we should probably set this for September sometime then.
Yes, Your Honor.
All right. is talk with the sign clerk, and we'll try and pick a mock day, not a motion day, do the sentencing in September sometime.
Much pleasure. With regard to the probation violation, would like an opportunity to confer with the prosecutor and Department of Corrections. Yes, that matter. Briefly.
Where it is not agreed upon the possible plea or the possible sentence of either the prosecutor, the defendant, or anyone acting in the interest of either, the court has commenced the plea is accurate. And there's been understandingly, knowingly, and voluntarily made, the plea is accepted in order done upon the corrections of this court. Sentencing will be set, bond is canceled. The case is adjourned to the date to be set for sentencing, September. Court will take a short recess for any talk regarding the probation violation.
Thank you.
All rise.
Recording stresses right out. And that is not fair or allowed.
She was like,
Deer
that's what I was waiting for.
deer in the headlights.
So I'm assuming you're all done with Mackie then?
I
I don't know.
I have the resolution.
All rise. Fifth District Court's now in session, the Honorable Roy J. Mink presiding.
You may be seated. In the case of the people versus Caleb Lee Keeler, counsel identify for the record, please.
Michelle resides here on that.
Your Honor, Austin on the roll, appearing on behalf of Mr. Keeler.
I don't know, that's Mr. Keeler. so-
And you are Caleb Lee Keeler?
Yes, sir. Mr. Rowe was trying to tell me something. Getting cut out for some reason.
Didn't understand what you were saying. I don't know, maybe you could turn your volume down just a little bit. We're getting some feedback from somewhere.
Your Honor, I think I could briefly explain to Mr. Keeler if I need to go more explanation. We might need a breakout room, but Mr. Keeler, the prosecutor has agreed to cap the minimum sentence at the low end guidelines as determined by the MDOC. For estimated inside the guidelines is 15.
Austin, I think you may be getting feedback from yours, I don't know, but we're getting feedback and reverb. We'll put you to a breakout room so you can talk, and then maybe you can adjust your volume levels, and then we can get back on the record. We're in recess.
All rise. All rise. 53rd Circuit Court is now in session. The Honorable Roy G. Mink presiding.
You may be seated. On case of people versus Eric Danya Heron, counsel identified for the record.
Michelle resides here on behalf of people.
John Melton for the defendant, Mr. Heron.
Was sort of set as a final pretrial. I know he's pled in a couple of the other cases. And this court wants to know what's going on with this case, or you're still in talks on it?
That's correct, Your Honor. We are, and as for now, we just have to continue to the trial date. And I apologize for being late. I was on a hearing in another court, and actually, we had a trial date already, and I was thinking this was canceled, so it's my fault. I apologize for being late. But nonetheless, I was detained in Saginaw anyway, so I apologize.
All right. What is the trial date on this one? Do we know?
I think we had a date in September.
8/17, August 17th.
Okay.
August.
So do we want to move that date or just leave it on August 17th?
We had talked about having the trial date after you were sentenced in the other case, Judge.
Okay. All right, we'll reset the trial date then for October and then we can talk about it again in September at the sentencing date.
I appreciate that.
Anything else for today?
No, you're not.
Nothing for me, Judge. Thank you.
All right, thank you.
I do believe we're back with Mr. Taylor.
You're all set, Mr. Melton.
Although I think Mr. Keeler must have found the top. There he is. There.
Recalling the case of people versus Caleb Lee Keeler.
Showers eyes, bring up people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Keeler.
You are Caleb Lee Keeler?
Yes, sir.
And are we proceeding with the plea, Mr. Rowe?
Yes, Your Honor.
All right. Mr. Keeler, how old are you?
21.
Raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Does it matter which count, count one or count two in this case?
Count one, please.
Count one? All right. And Mr. Keeler, you received a copy of the information or gone over that with Mr. Rowe, is that correct?
Yes.
All right. And Mr. Rowe, is he waiving reading of the information for today's purposes?
Yes, he is, Your Honor.
And previously waived preliminary examination, is that correct?
Yes, Your Honor.
All right. Mr. Keeler, you're being charged with count one, criminal sexual conduct in the third degree. That's a felony. It carries a maximum penalty of 15 years in prison, mandatory AIDS STD testing, DNA is to be taken. You will also be subject to sex offenders registration. This is a tier 3 offense for that registration purposes. Otherwise, the minimum is discretionary with the court. You understand the charge and the possible penalties?
Yes.
There's one of 3 possible pleas you may make to this charge. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. Do you understand the one of 3 possible pleas you may make?
Yes.
Answering count 1, criminal sexual conduct in the third degree, how do you plead?
Guilty. I was told to accept the deal, so that's what I was doing.
Mr. Keeler, you plead guilty. So you want to
Okay.
talk about that?
All right, again, I'll ask you, how do you plead, Mr. Keeler?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be?
Yes.
Court further informs you that if your plea is accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so, and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes.
You understand by pleading guilty, you give up each and every one of those rights.
Yes.
What is the plea agreement, Ms. Ambrositis?
Your Honor, in return for the defendant's guilty plea to count 1 in the felony information, the people would move to dismiss count 2 upon sentencing and running the appropriate appeals period. There is an agreement that his sentencing would be at the bottom end of the MVOC determined guidelines, which is a Briggs-Killebrew agreement. Restitution is to be determined to the minor victim. And that is the completion of the agreement.
Mr. Rowe, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Keeler, did you hear it was put on the record as the plea agreement?
Yes.
Did you understand it?
Yeah.
And are you in agreement with it?
Yes.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No.
Has anybody threatened you or your family in order to induce you to plead guilty?
No.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No.
Is it your own personal choice to plead guilty?
Yes.
And are you doing so freely and voluntarily?
Yes.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes.
In light of everything the court has told you, do you still wish to plead guilty?
Yes.
Drawing your attention to on or about September 30th of 2020, were you in the city of Clare County, Michigan?
Yes.
And did you engage in sexual penetration fingers to a genital opening with a child who was at least 13 years of age, but under 16 years of age?
Yes.
Any questions, Ms. Ambrositis?
No, thank you.
Satisfied with the factual basis?
Yes.
Satisfied with the factual basis, Mr. Rowe?
Yes, Your Honor.
Has the court complied with the court rules, Ms. Ambrositis?
Yes.
Has the court complied with the court rules, Mr. Rowe?
It has, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either the prosecutor, defendant, or anyone acting in the interest of either. Court is convinced the plea is accurate, has been freely, voluntarily, understandably, and knowingly made. Plea is accepted and ordered entered upon the records of this court. Sentencing will be set for October 12th at 10:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond's got to be canceled in this case.
It does, Your Honor. And I would ask the sentencing occur in person.
All right. All right. Bond's got to be canceled. Mr. Keeler, you're going to need to report to the Sheriff's Department today by 5 o'clock. You understand that?
Okay.
All right. And then when you get to the Sheriff's Department, the Department of Corrections will contact you and give you a packet of information to fill out, and then they'll do an interview with you. You understand that?
Yes, sir.
All right. Case is adjourned to the date set, time set for sentencing. If you fail to show up to the jail today, Mr. Keeler, you can face, you could face new charges, or that plea agreement can go out the window. You understand that?
If I don't show up is what you're saying?
Yes. So make sure you appear today at the jail.
I'll be, is it gonna be the Sheriff's Department in Harrison?
Yes.
Okay.
Sheriff's Department. All right. All right. You're all set, Mr. Keeler.
All right, thank you.
All rise. 50th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. And the cases, the people versus Jamie Lorenzo Sizemore Jr. Also identify for the record, please.
Sure, besides, people.
Scott Moore for the defense.
You are Jamie Lorenzo Sizemore Jr.
Yes, sir.
And Mr. Moore, you just substituted in to take these cases.
Yes, Your Honor. Looking at my electronic file, it appears that we have an appearance, prepared one of these yesterday, as well as the substitution of attorney. That's in 6590. 6591 and 6592. I don't know if it's found its way to the appropriate files yet. But
We have the substitutions of attorneys. Didn't notice the appearance in them. But
as I indicated, Your Honor, my file shows that we created those documents, or we sent those.
yeah, we have the substitutions of attorneys. They're all signed.
And the appearances are either on their way or will be sent forthwith.
We have the trial dates set in all three of these cases for August 19th. So what's your pleasure?
Mr. Sizemore, my name is Scott Moore. I've been assigned to take over cases from Mr. White. I'd like the opportunity to discuss the case with you in my office. And to make that happen, I would ask that we adjourn the trial date so that we can prepare.
Yes, sir.
That, Your Honor, we do ask that the trials be adjourned to a later date.
All right. How long of adjournment do you think you need? 90 days? Or?
I think 90 would be appropriate. Yes, sir. With the final pretrial, maybe 2 weeks before that.
Okay. All right. That's what we'll do. I'm not sure. Have we got copies of Mr. White's files already?
They're coming over.
They're coming over. Okay.
Mr. Sizemore, do you have a pen with you?
I do.
All right. Again, my name is Scott Moore, M-O-O-R-E.
All right.
You could call Kim at my office. The number there is 989-386-2699.
989-386-2699.
That's correct. If you could call Kim, she'll schedule an appointment when we can meet at your convenience. All right?
Yes, sir. Thank you.
Thank you.
Thank you, Your Honor.
All right. You're all set. You can sign off. And, do you want Mr. Young present, or do you want to just call the cases?
I think we can just call the case.
All right. On the case of the Pig versus Kenneth Joseph Young, counsel identified for the record.
Which one resides for the people?
Please report Scott Moore for the defense.
Just taking over Mr. Young's cases, and I know he has another new case. Trial scheduled in these cases, one case for August 19th, the other is probation violation.
Yes, Your Honor. I spoke with Mr. Young in connection with the new assignment, which is scheduled for probable cause conference summary, I believe August 4th, sometime next week. In light of the gravity of that charge, we are asking the court to adjourn all the other matters pending in this court. Mr. Young understood that for convenience of the parties, it would make sense to have one attorney handle all of those matters. So he agreed to that. And Mr. Rowe authorized me to sign on his behalf the substitution, which which has been tended to the court in those files. Appearances will be filed before.
How long is the adjournment of the trial date in this case too?
Well, Your Honor, maybe putting the cart before the horse, I fully expect that that matter will be bound over to circuit court in the next month or so. So perhaps we could set these for status conference in 30 or 60 days and then try to align the schedule if that's necessary.
All right, we'll do that. We won't reset the trial date at this point, but we'll set a status conference on all the cases.
Your Honor, I do recognize that this would cut into any speedy trial complaint to my client. He understands that as well.
Anything further on Mr. Young's case?
Nothing.
Not to the defense. Thank you.
All right. We are in recess.
All rise. All rise. 50th Circuit Court is now in session. The Honorable Roy G. Mink presiding.
May be seated. On the case of the People versus Summerlee Marie Darabos. Counsel identified for the record.
Morning, Your Honor, Mark Webb on behalf of the people.
Morning, Honor, Karen Tomchek on behalf of Ms. Darbos.
And Ms. Darabos has not appeared.
She has not, Your Honor. However, she has kept in good contact with me throughout this case. I did try to call her. The phone came back that it was not, it could not be completed at this time. Your Honor, based on her prior appearances in court, and I would note to the court that she does have a district court matter this afternoon, I would ask that the court set this matter for a show cause.
Well, instead of doing that, court is going to just, if she doesn't appear by Friday morning, then the court's going to issue a bench warrant for her arrest, cancel and forfeit her bond. New bench warrant will be for $25,000 cash. So you can get a hold of her and get her to report and call the court and we can set something up.
Okay, Your Honor, are we, this matter is set for trial on August 25th. Are we leaving that on or are we adjourning that?
I'm gonna leave it on for now, but
Okay.
you know, if we don't get a hold of her, she doesn't report or she's not caught after a bench warrant's released, then, you know, in a couple of weeks, I'll have to think of something else.
Okay, Your Honor, thank you.
All right,
Thank you.
we're in recess.
All rise.
Ms. Matthews, I'm gonna have you go ahead and unmute your microphone so that when the judge addresses you, you're able to. Okay,
Yes, ma'am.
thank you.
All rise. 55th Circuit Court is now in session. The Honorable Roy G. Mink presiding.
May be seated. On the case of Allison Matthews versus James Matthews, come up to the table. You are Allison Matthews?
Yes, Your Honor.
You are James Matthews?
Yes, sir.
All right. You filed a motion requesting to be allowed to get onto the property to get your personal possessions, is that correct?
Well, I just want to get my kids and my stuff.
Your what?
My kids, because I have custody of my kids now. I'm just trying to get our stuff out of the house. It's been ransacked by everybody.
Okay. And is the divorce matter been settled?
No, we just now are into August 5th for the custody for friendly court.
Okay, so you haven't settled any of the property issues in the divorce?
No. She was in default for not signing or not responding to it.
Well, since there's a divorce going on and there's an issue as to who gets what property still to be decided, the court's not gonna allow you to go onto the property to get things. Not unless you can, somehow the two of you come to an agreement as to what you can go and collect. If you got an agreement as to what you can pick up and take from the house, then that's something different, but at this point, then it's just you saying what you want and taking what you want with nobody deciding as to who gets that property in the divorce, so.
Well, I mean, Your Honor, up until this point, it's all been her boyfriends going in and out of
I
the house.
know it's a problem, but it's a problem that the two of you have to work out. As to what property, if she gives you a statement saying you can go on and take this property and that property, then the court will grant an order for that. But until then, no. All right, we're in recess.
All right.
How do I get something from her when I can't even talk?
Write to me, write to me.
I can't find the file. Where's the file? I've got a file.
You've been like that all day.
All right. 55th District Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. On the case of People versus Keith William Branson.
Good afternoon, Your Honor. Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Richard Lee on behalf of Mr. Branson, Your Honor.
You are Keith William Granston?
Yes, sir.
This was a delay of sentence, an updated case report that has been prepared. Any objections to the updated case report or anything of a factual nature that anybody want to add to explain or controvert in the report?
The people have none, Your Honor.
No objection, Your Honor.
All parties agree that Mr. Granson has successfully completed the delay of sentence?
People are satisfied, Your Honor.
Yes, Your Honor.
So the court will allow Mr. Granson to withdraw his plea to the OUIL third. We'll use that same factual basis for the conviction for the OUIL second. But we'll sign a new judgment to that effect and release Mr. Granson from probation. Anything further, Your Honor?
Thank you.
Nothing further? We're in recess.
All right.
I guess we can. We can.
Oh, he went into the room?
Scott Moore went into a breakout room, but we have Karen Tomczyk. So Miss Darvos is outside.
Okay. You may be seated. Yeah, I got it right. Yes. On the case of People versus Summerlee, Marie Darabos, counsel identified for the record.
Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Thank you, Your Honor. Karen Tomczyk, appearing on behalf of Ms. Darvos.
You are Summerlee Marie Darabos.
Yes, Your Honor.
This was put on today's docket for a final pretrial. Set for 11:45, and you failed to appear at 11:45.
Yeah, I didn't realize I had two separate court cases.
The last court date, on July 12th, court told you you need to appear in person, and that the date was July 27th, which was set back in May 13th and sent out. So you've got plenty of time and notice of today's truck date. Time, whether you just forgot or whatever. So what the court's gonna do is find you in contempt of court for being late and fine you $50. As far as the pretrial goes, any new offers or the same offer on the table, no offer? What's going on?
There is no offer in this case, Your Honor.
Has there been an offer made by the defendant?
And any counteroffers have been declined.
Okay. All right. So we're still set for trial then?
Yes, Your Honor.
That's August 25th at 9 a.m. Any reason to meet before then?
I don't believe so. I don't see any, Your Honor. We will keep up to date with the court as to the court and its trial docket, and if this one is likely to run on that day.
All right. Mr. Arbos, can you pay the $50 today?
Yes, I can, Your Honor.
Go back to the clerk's office and pay.
Okay.
We're in recess.
All right.
All right, Mr. Yass, I'm gonna have you unmute again, just so that if the judge talks to you, you can speak with him. Okay?
All right. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
May be seated. In the case of people versus William Rydell Yates, counsel identified for the record.
Thank you, Your Honor. Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Please, the court's got more for you.
You are William Rydell Yates?
Yes, sir.
Here today on a motion to revoke bond, is that correct?
That's correct, Your Honor.
You may proceed.
Your Honor, we have supplied the motion regarding the particular instances where the defendant has been arrested and is now lodged in our jail relating to conduct that occurred yesterday at Clare County Fairgrounds. There's also allegations in that petition that he has violated statutes under the Motor Vehicle Code and the Park Code at a incident at Wilson State Park. Our conditions are that he should not violate any laws in the state of Michigan. I've attached the bond conditions and the signature page where Mr. Yates indicated that he acknowledged and understood the conditions of his release. Therefore, we would ask that you take those things into consideration when you set a bond and or modify the conditions of his pretrial release at this point in time. He is set for sentencing coming up the early part of August on this particular case, Your Honor.
More?
Your Honor, the defense moves to dismiss the petition or motion. As the prosecutor indicated, she is relying on paragraph 3D of the that was initially entered by Magistrate Rappel on April 19th, continues with the bind over that states in part did not commit any crime while released. While the people have made allegations that there were two separate misdemeanor offenses committed by my client, it's my understanding that he has not been charged, or even if he has been, there's been no judicial determination as to whether a crime was committed. The presumption of innocence obtains until such time as he enters a plea to one or both of those offenses, or the court or a jury renders a conviction. finding of guilt. So for these reasons, we believe that the motion is untimely and there is no other allegation in the motion submitted by the people that would support revocation or modification of the bond as it stands. Thank you.
Rebuttal?
Nothing additional, Your Honor.
Has he been charged for the crime?
He has indeed, Your Honor. There is a district court case file number 21-06543-ST, and he was just charged again this morning with disturbing the peace. And I do have a case number as of yet for that misdemeanor from last night and this morning from the district court.
I will note that the prosecution did state the case number for the June 7th allegation. I have not been appointed to represent Mr. Yance on that matter. I don't know if he requested counsel or where that stands. Thank you.
Your Honor, if I may, I will tell you that he's scheduled for remand in district court on that June 7th case on August 3rd, 2021. No attorney has filed an appearance.
Anybody have any case law regarding whether or not being charged with a crime the same as violating the condition of committed crime?
I don't have any specific case law, but I liken this to no contact order. There need not be a conviction of a no contact order. That is a condition of bond. And if there is even, I would guess the more likely than not, probable cause standard that would be sufficient.
Your Honor, I would state that the defense does not bear the burden of any part of this case. But that said, the language on the face of the order is unambiguous. Do not commit any crime while released. But the crime cannot be a crime until there's been adjudication. Other than that, it's charged misconduct. So for those reasons, I would suggest that absent any case law to the contrary, I ask the court to dismiss this.
Does anybody have information as what the standard is? Is it just the preponderance of the evidence regarding bond violations?
I do have, I have a case, people, Miyazuki, 315 Bishop 414, 2016 case. It does say that bond conditions are court orders and that you may hold a defendant in criminal contempt for violating their condition. I realize that requires a hearing, and if we need to set this for a hearing to establish that for criminal contempt, I'm not opposed to that. If you give me a few minutes, I can pull up the case and see if there is a burden of proof within that statute, but it'll just take me a moment to do that.
I have no objection. As regards to the case that's been cited by the prosecution, People versus Slevich, MYSLIWIEC, reported at 315 Michigan Appeals, 414 in 2016 case. Violation of violation is punishable by contempt because the court's decision in setting bond is a court order and a bail decision is an interlocutory order. Bond condition prohibiting the defendant's use of alcohol is a court order punishable by contempt. where the trial court orally ordered that a condition of the defendant's bond was to abstain from possession or consumption of any alcohol, then issued written witnesses which required the defendant to have no alcohol. The squib that I'm reading from, which is from the MJI contempt bench book, says nothing about the standard of proof or what proofs were presented.
Anything further from either party?
Nothing from the bench, Your Honor. Thank you.
Nothing further, Your Honor.
Court's gonna find that, being arrested, with new charges is a violation of the bond condition of not violating, not committing a crime when it was released. Court's just gonna hold him in civil contempt and revoke that bond, set a new bond at $30,000 cash.
The original bond was a surety bond.
Cash, 20,000 cash surety bond.
Thank you, Your Honor.
So, Mr. Yates, you have to post a new bond, you understand that?
Yeah.
All right. And the new bond will include all the previous conditions in the old bond. Anything further?
No, Your Honor, thank you.
Thank you.
We're on recess.
All right.